Hey YouTube, CSM10495 here. Let's jump right into it. Chapter 6, Civil Rights. Let's start by defining what a civil rights issue is. So, civil rights issue. Now, a civil right issue, I guess, can be classified as when a group is denied access to facilities, access to facilities, opportunities, or services. Um, that are readily available to other groups. Okay. And this group is usually defined along, or not usually, it is defined along ethnic or racial lines. Okay. And the issue itself, usually the question about it is whether the difference in treatment is reasonable. And reasonable, of course, is open to interpretation, as always, as things like that are. And some are not. And so overall, classification by race is subject to strict scrutiny. Okay. All right, so that's section 1. Section 2, the black predicament. So so let's talk a little bit about historical context. So there's been so before the changes in civil rights began to occur, there was a long standing of discrimination. There we go. And contrary to what some people believe, there was definitely a lot of tension in both the North and South United States. Some people think, oh, the North, everyone was getting along. They abolished slavery earlier, so they must have been more lenient in terms of equality. But no, they were, but not to the point where it was really equal. And even today, it could still be argued that it's not equal. Um, there were a lot of lynchings of colored people, and this really it shocked whites, but at the same time, really little was done on it. So they were kind of bored by this, but they didn't do anything. I don't know, maybe they thought it was normal or this was just the way it was. So for many years there was uh, little support for equality, for racial equality. Little support for racial equality. Um, Integration, desegregation, integration, and a civil rights movement. Well, that was soon to change. Okay. So, how can we get stuff done? How can this change? Well, there were two things they really needed to do. They needed to first find more. the civil rights movement needed to find more white allies and shift policy making areas, such as Congress, other parts of government, the president. All right. And so the civil rights movement would really do both. It would broaden its base by publicizing grievances, and at the same time, it would move towards a legal struggle with Congress and passing various acts we'll get into later. So they were able to do both these things, and that's why equality was pushed forward. So let's move down. The campaign in the courts we'll go to next. So this is a big problem was the 14th Amendment sounded great. 14th Amendment. And the two big clauses of the 14th Amendment were equal protection under the law, and I believe I already went over the 14th Amendment on a previous video, but this is very, quick, basic, and due process, which is fair legal proceedings for all. All right. And the problem is that there was a broad interpretation. I mean, nah. The problem was there was a narrow interpretation. So the interpretation was oh, they have same legal rights, so they can take me to court. But that's not really, at least that's what we believe. That's not really what they meant. They wanted more equality. They wanted equal protection. They want everyone to be the same. Well, in keeping with that thought, we had the Plessy v. Ferguson case, which gave the precedent of separate but equal. And so it was okay to have black schools and white schools as long as they were equal. However, the NAACP, National Association for the Advancement of Colored People, would campaign, along with others, of course, that separate schools are inherently unequal. And the thought process behind this was, all right, so if all the whites are at this school and all the blacks are at one school, the blacks are gonna be they're gonna be envious of something the whites have, and the whites are gonna be envious of something the blacks have. There's no way to make both schools equal. The only way to really equalize things are if they both go to each other's schools as well, or desegregation occurs. So really, the question this would finally lead to the ultimate question. Can separate be equal? And guess what? This would be answered down the road with another landmark Supreme Court case. Brown versus Board of Education. Plessy and Brown are both very important Supreme Court cases, so I would know at least the basics of them. They probably come up in a multiple choice question. That was in 1954. And the ruling in the case was that separate schools are inherently unequal, and therefore desegregation of schools should occur. Now, the interesting thing was was the Supreme Court said in the ruling, they in referring to how fast, what year, how long should this take for this mixing to occur, they said with all deliberate speed. Now, of course, this is meant to be very ambiguous. It doesn't give a real date. It doesn't give a real how long it should be. So it was ambiguous in terms of how long the integration should take. So there'd be resistance all the way into the late 60s, early 70s even. Anyway, so what was the rationale? So the rationale of the ruling, just a little bit more on it, that the rationale to Brown v. Board of Ed was that it's detrimental to students to create a sense of inferiority. So some students are automatically getting a sense of inferiority because, oh, I'm white, I'm not allowed to be with the blacks. I'm black, I'm not allowed to be with the whites. That's not correct there. That was the problem. That was their rationale. Um, they also said it was because the 14th Amendment was unclear and we needed a furthering of equality. And a very important thing was that this was a unanimous decision. This was very important. Meaning all justices voted to desegregate schools. Okay, this is really important because the Supreme Court wanted to send a message. Okay, they wanted to send a message that desegregation should occur. We should not be separate. And they were able to do that by saying that all justices agreed on it. Even if there were a few people who held back, there would be doubts in people's mind that this was a good idea. But having all of the justices vote this way was a big deal, and they needed that to happen. Okay, so let's just talk a little bit about the ambiguities of Brown. Um, so in integrating schools, um, do we have is there unrestricted choice or integrated schools? So in other words, should I be able to send my student to this school or this school? If I don't want him to be with black kids, I can send him further away from where they are, or should there be forced integration? Okay, so that's this is basically forced. Well, this one is I can pick where my student wants to go. If I want them to go with black kids or white kids, I pick where they go. Okay, so and furthermore, there are two different types of segregation that would probably be good to know. Go away. De jure segregation and de facto segregation. De jure is segregation enforced by law. And de facto segregation is segregation enforced by society through habits. Okay. All right. So gonna throw in another Supreme Court case here to finish up this section. Those two were the most important. It's also good to know this one. Swan v. the Charlotte. Let's see if I can fit this. Mecklenburg Board of Ed. This was in 1970, And the ruling was that busing is appropriate to promote desegregation. All right, that sounds pretty good. And of course, I'm sorry. Let's see. So so some people look for remedies to try to halt or slow the desegregation of schools. And this was through different quotas, saying, okay, only this number of people of this race busing, bus their children further away or even closer. And they'd also redraw district lines so that in a locationally African American area, they would have this area be a District 5 area, while the white area would be a District 4 area, or something like that, so they wouldn't have to go together, just based off technicality. So, our next section is we're gonna go back up here to the campaign in Congress. So, it was important for in order to get things done, that we needed a mobilization of opinion by dramatic event. And this was important to set the agenda. We needed to get these things on the. We needed to get these things in Congress, bills to fix these problems, to get away from the segregated lifestyle. And so, how would we do this? Well, there were sit-ins, freedom rides, peaceful protest. Good name to know there is Martin Luther King Jr. And even some violent protests by some other people also was possibly helpful. So in the end, there was some mixed results. They were able to set the agenda, but at the same time, they weren't getting a lot done for some time. But eventually, it would start to happen. So there were some defensive positions. So there were some defensive positions against civil rights. First of all, the Senate Judiciary Committee was controlled by Southern Democrats. And the House Rules Committee was chaired by Howard Smith, who worked to keep civil rights legislation from making it to the floor for a vote or even a debate. And even if anything got very far in the Senate was threatened by filibuster, by a possible filibuster. And furthermore, so that was Congress, but even President Kennedy was pretty reluctant to push anything forward. So some four big developments happened to break this deadlock to push forward civil rights legislation. So first of all, there's a let me first say what changed. So there was a change in public opinion. Um, the media even helped out by focusing on segregationalists, and they even made them out to be kind of crazy. I mean, I guess an example of this would kind of be the KKK in their bathrobes and pointy hats. Also, the Kennedy assassination, because Kennedy was very conflicted about impeding civil rights legislation such as the 1964 Civil Rights Bill, which eventually will be signed by LBJ. So, and in 1964, there was a Democratic landslide. And what do I mean by a Democratic landslide? I mean that LBJ was president, LBJ was a Democrat, and Congress was also Democratic. So the two branches that could go Democratic or Republican were both Democratic, therefore making it easier to pass Democratic bills. So then from 1957 to 1968, there were a few bills that passed. In 1957, 1960, 1965, voting rights laws. In 1968, the housing discrimination law. Which meant that you can't not sell housing based on race, age, or gender. And in 1964, the high point, this one is the one that I've seen come up a lot on exams. So keep your ears open for a moment as I try to erase that. In 1964, there was a Civil Rights Bill. And I'm gonna say what it said. It ended unequal application of voter registration requirements and ended racial segregation in schools. Furthermore, in schools, workplaces, so at your job, and facilities that serve the general public, which we'll call public accommodations. Accommodations. All right. So, from this, what have we really seen? We've seen, since 1964, we've seen a dramatic rise in black voting, which I think is epitomized by the election of President Barack Obama and second term. And the mood of Congress would shift towards pro civil rights. Now, I'm just going to mention, since we have a little space here, let's talk a tiny bit about racial profiling, which refers to increased likelihood of being suspect because of race or ethnicity. Likelihood and this is illegal at this point. And but at the same time, the opposite side, because this I understand it sounds wrong, Um, I don't like this guy because I think he's more likely to. This black guy here, I don't want him in my bank because I'm scared he's gonna rob my bank. That's not right. So, but at the same time, maybe it is reasonable if members of a certain race are in fact more likely to commit a crime. So if the percentage of bank robbers was higher for African Americans, it maybe it is reasonable. Yeah, this is a bad example. Forget it. The example that the textbook gives is a profiling of young Middle Eastern men may very well have prevented the 9/11 attacks. I don't know, but at the same time, this definitely does attract charges of racism, rightfully so, in my opinion. And my example is very bad. Forget it. The textbook is much better at this stuff. So let's move on to women and equal rights. So there's a big difference. We'll call it a critical difference from the battle for women's rights and African Americans. And what I'm gonna put it a little bit all in perspective here. For women, it seems like they're always not always, but they have a certain standing already, and they're just trying to get on the same level as men. And at the same time, African Americans are doing this, but they had a much lower standpoint at one time. Now, though, the difference is a little bit less. Now it's really more of a gender thing. But at one point, they were both just trying to get elevated to the same level of white men. So, so, so women's rights. Let's see. The Seneca Falls Convention of 1848 um, was an event that had to do with suffrage for women. Suffrage is the right to vote. And so, what has Congress done? There are other. It's definitely more obvious, like a lower pay, less time off, and other more obvious things that women have historically not had in terms of equality with men. So what has Congress done? So over the years, Congress has said that there should be equal pay for equal work. They have even sometimes allowed gender discrimination in employment. But so that was Congress. What about the Supreme Court? Gender. Here are some gender-based differences that have been prohibited by the courts. Um, they must have the same age of adulthood, men and women. Drinking age. They must have the same um, arbitrary employee height weight requirements. So if this job requires someone who's 6 foot tall, 200 pounds, It's the same for both men and women. Mandatory pregnancy leaves are not allowed, are prohibited. So you can't force someone to take off. And it's also not allowed to have unequal retirement benefits. Now, where are gender-based differences allowed? Well, they're allowed in gen. Just want to put a title. Gender-based differences allowed. Well, how about let's do with an obvious one. All boy or all girl schools. If it's an all boys school, we do not have to admit a female student. How about a widow's property tax exemption? There can be delayed promotions in the Navy, even. That one kind of surprised me. Well, at the same time, let me just point something out here. Women, and it relates to the all boy, all girl schools, women must be admitted to all male state supported scholarships, state supported military colleges. Also, in terms of sexual harassment, you cannot request sexual favors as a condition for employment. And in terms of sexual harassment, the employer is liable. And this should be fairly self-explanatory. Um, in and also, in terms of sexual harassment, still, if there is a hostile or intimidating work environment, the employer is at fault if he is considered to be negligent. And furthermore, just to put this all in perspective, there are not many laws governing this. And that leads to there being many vague and inconsistent court and bureaucratic rules telling us really what's allowed, what's not allowed, what would get you in trouble, I think it's pretty good to go with your conscience on it a lot of the time. But now let's also get into privacy. And I'm going to do textbook goes a lot into this. I'm going to go into the couple things about it that I think is likely to come up on the exam. You could always look at the textbook for more information on any of these topics. I really just go over the ones that I think are important and are they're all important, but the ones that are big on the AP. at least in my own AP experience. So, privacy. Let's talk about the Griswold v. Connecticut case. This is a Supreme Court case. That was in 1965. And it involved the use of contraceptives in Connecticut. It had been illegal for years, and the case ruled that you're allowed to use them because there are zones of privacy. And it's your business, you do it. And so that's that case. And the big one that's still talked about today a lot is Roe v. Wade, which said that there is a right to privacy. Again, you see the trend. Right to privacy encompassing a woman's decision whether or not to terminate a pregnancy. So whether or not to get an abortion. And the big thing about this is, and the part that's still argued today is, there are controversies over when human life begins. All right. So now we can go back up here, all the way up to the next section. And that section is affirmative action. And it's not as long as the last one, trust me. We're in the final stretch here. So, affirmative action is an action, this is a definition, or policy favoring those who tend to suffer from discrimination. So, equality and results. The only way to overcome, this is the thought process behind affirmative action. To overcome racism and sexism, remedies must be made. And really to hit the nail right on the head, equal rights are not enough. People need benefits to get them on the same level. Now, equality of opportunities. There's another P in there. Opportunities. In order to get equal opportunity, there could be reverse discrimination to give someone who's less likely to get the job an advantage to get the job. And furthermore, laws must be colorblind and sex neutral. Government should, and in keeping with the idea of being colorblind and sex neutral, a big job that, if you believe in affirmative action, that the government should have is it should work to eliminate barriers. really to work to even the playing field. It's important to note in terms of affirmative action, congressional efforts to defend affirmative action have not been very successful. But this is a little interesting thing that I found in the textbook that I thought a little bit hits the hail, just throws in some stuff from earlier. Affirmative action is in line with pop culture, with political culture. I'm sorry. And it's in line with it because it supports individualism, and at the same time, it supports needy. So it supports the idea that you should work for yourself, you know, but but at the same time, we want to put people on the same playing field. We want to put people on the same level. So it really does go in line with political culture. So it's kind of surprising that it hasn't been so successful to defend in Congress. All right, last topic. This is a relatively it's getting a lot more attention now, but we're not gonna talk very much about it because it doesn't come too much. I don't think it's ever come up much on the AP. It didn't come up on my test at all. But so gays in the Constitution. Originally, state laws could ban homosexual activities. And so to go against these state laws, the argument has been rights to privacy, marriage, in some cases marriage, civil unions. But the textbook, I don't even think the textbook's up to date enough. I mean, in New York, this is legal now. So I think really all they could ask you, maybe multiple choice about it. What's the trend in allowing gay marriage? So I guess the trend is, people are becoming more accepting, which is allowing for more gay rights. And this is happening over time. So I guess they could ask you, oh, um, which of the following is true? And one of them could say, over time, people are becoming more accepting of gay rights. So, yeah, the textbook goes a little bit more in depth. I think it's still new a subject to come up hugely on the AP. That's all you really need to know. CSM 10495, Chapter 6, Civil Rights. See you in the next video. Bye-bye.